Can you still apply for British citizenship if you have a criminal record? Hello, my dear friends. Svetlana Shlapak, the founder of UKVisaSuccess.com, is here. Today we are going to discuss when British citizenship applications are likely to be refused, whether or not you need to disclose spent or unspent convictions, what the Home Office means by sentence-based thresholds. We'll also discuss the definition of persistent offenders, and we'll consider non-custodial sentences and other out-of-court disposals, how they are likely to affect the outcome of naturalization applications, and also we'll consider the list of these non-custodial sentences. Before I answer all these questions, guys, I would like to let you know that I've created mind maps, overviews containing some useful information for those who are thinking to make their naturalization application, whether following the 5-year route or the 3-year route. These mind maps are absolutely free, and you can get them within 60 seconds or less after submitting your request at ukvisaSuccess.com/BC, where BC stands for British Citizenship. Okay, as you probably know, irrespective of whether you are applying for British citizenship as a spouse of a British citizen or following the 5-year route, one of the requirements that you need to meet is called the good character requirement, and different types of criminality will be considered when assessing good character element of your naturalization application. And the purpose of this video is to deal with exactly that, to consider the criminality aspect of the good character requirements. Well, first of all, let us start with considering when British citizenship applications are most likely to be refused. Having a criminal record does not necessarily mean that an application will be refused. However, a person who has not shown respect or is not prepared to abide by the law is unlikely to be considered of good character. The applications for British citizenship, also known as naturalization applications, are likely to be refused if the applicants have a criminal conviction which falls within the sentence-based thresholds, and I'll explain what this means in just a moment. And also when the applicants are persistent offenders, or where they have committed an offense which has caused a serious harm, or where they have committed a sexual offense, or their details are recorded by the police on a register. Disclosure of spent and unspent convictions. It is a myth that applicants are required to disclose only unspent convictions when making their British citizenship applications. Spent convictions are convictions where a certain period of time has passed. Guys, for the purpose of making naturalization applications, you need to make a disclosure of all convictions, regardless of whether or not they are spent under the Rehabilitation of Offenders Act 1974. According to the Home Office guidance to its caseworkers, the decision makers may take into account any past conviction, regardless of when they took place, and this is because nationality decisions are exempt from Section 4 of the Rehabilitation of Offenders Act 1974. According to this Section 4, certain convictions can become so-called spent after a fixed period of time. The only exception to this disclosure rule is where the applicant is a resident of Northern Ireland, in which case the applicant is only required to disclose unspent convictions. Now, let me explain what they mean by the sentence-based threshold. The application will almost always be refused if a person has a custodial sentence of 4 years or more. If there was a custodial sentence between 12 months and 4 years, they can only submit their application after 15 years since the end of the sentence. And if there was a custodial sentence of less than 12 months, a person will need to wait for at least 10 years since the end of the sentence. If there was a non-custodial sentence or other out-of-court disposal that is recorded on their criminal records, a person will need to wait for at least 3 years prior to the date of their application. But what about suspended sentences? A suspended prison sentence must be treated as a non-custodial sentence. The exception is where the suspended sentence is subsequently activated. This means that the person reoffended or failed to comply with the conditions of that sentence. Where this happens, the decision makers will look at both the original suspended sentence and the circumstances leading to the activation of that sentence, and the amount of time in prison a person was sentenced to once the original suspended sentence was activated. But what about convictions and sentences imposed outside the UK? Guys, any overseas convictions or non-custodial sentences must be treated in the same way as the ones imposed in the UK. Okay, and now you should bear in mind that even if a relevant period of time has passed since the last sentence, but a person is considered to be a persistent offender, the application may be refused. A persistent offender is a repeat offender who shows a pattern of offending over a period of time. And this can mean a series of offenses committed in a fairly short period time frame, or offenses which escalate in seriousness over time, or a long history of minor offenses. When considering an application from a potential persistent offender, the decision maker will take into consideration the following: the number of offenses committed, the seriousness of those offenses, and the time scale over which they were committed, the impact of the offenses on the public, and whether the offenses have escalated into seriousness. What about non-custodial sentences and other out-of-court disposals? Before we start considering how they may affect the naturalization applications, first of all, let us define them. They may include, but are not limited to, absolute and conditional discharges, fines, fixed penalty notices, penalty charge notices, and penalty notices for disorder, cautions, warnings and reprimands, community resolutions, community sentences, and civil orders. Absolute and conditional discharges are considered as non-custodial offences or other out-of-court disposals recorded on a person's criminal records. A fine counts as a criminal conviction and forms part of someone's criminal records. Fines must be declared and may result in a refusal if received within the last 3 years. Failure to declare may result in an application being refused on the grounds of deception. Even where a person does not have a fine within the last 3 years, the application may be refused if a person has received multiple disposals of this kind that show a pattern of offending. Fixed penalty notices, a penalty charge notice, and penalty notices for disorder are imposed by the police or other authorized enforcement officers for traffic rule violations, environmental and civil violations. Receiving one does not form part of a person's criminal records. A fixed penalty notice will not normally result in the refusal unless the person has failed to pay or has unsuccessfully challenged the notice and there were subsequent criminal proceedings resulting in a conviction. In such instances, they should be treated in line with the sentence imposed by the court. However, guys, you should bear in mind that multiple fixed penalty notices over a short period of time should demonstrate a disregard for the law and therefore demonstrate that someone is not of a good character. A caution, simple or conditional, use caution, warning or reprimand are all examples of out-of-court disposal which are recorded on a person's criminal records. Even though a person does not have a caution, a warning or reprimand within the last 3 years, the application may still be refused if the person has received a multiple disposal of this kind that show a pattern of offending. Community resolutions. A community resolution is used for less serious offenses or antisocial behavior. It is a tool which enables the police to make decisions about how to deal more proportionately with a lower level crime and is primarily aimed at first-time offenders where genuine remorse has been expressed and where the victim has agreed that they do not want the police to take more formal action. In establishing whether the good character requirement is met, the decision maker will consider the seriousness of offense and whether it was a first-time offense. Community sentences. Where a person is convicted of a crime by a court, they may receive a variety of sentences other than custody, and these are often referred to as community sentences. They are designed to allow offenders to follow programs to rehabilitate them or to do work for the community. Such sentences can include, but not limited to, alcohol treatment, attendance center, compulsory unpaid work, drug rehabilitation, exclusion from specified areas, mental health treatment, participation in specified activities, prohibition from undertaking specified activities, residence requirements, supervision, undertaking accredited programs, and so on and so forth. Having one or more of the above is considered to be a non-custodial sentence or other out-of-court disposal that is recorded on a person's criminal records. Guys, the same pattern is here. Even where a person does not have a community sentence within the last 3 years, the decision maker may still conclude that a person is not of good character and may refuse the application if they have received multiple disposals of this kind and show a pattern of offending. And finally, civil courts. The criminal and civil courts have numerous powers to make orders relating to a person's conduct, and whilst the making of such an order does not result in a conviction being recorded against the individuals concerned, this will have a bearing on the assessment of that person's character. An order may contain conditions prohibiting an individual from carrying out specific antisocial acts, for example, entering defined areas. Civil order will not normally result in refusal of naturalization application unless the person has violated or broken the civil order and where there were criminal proceedings as a result, or they have received an order or orders which would suggest a pattern of behavior that calls into action their character, or there are other factors to suggest the individual is not of good character. In cases where a person has violated or broken the civil order and there were criminal proceedings as a result, the decision maker will consider this as a conviction and assess it in line with the new sentence imposed. And this is it, my friends. In this video, we've covered all we intended to. We've established that there are convictions which will negatively affect the outcome of the naturalization application. And unless you are a resident of Northern Ireland, you need to disclose all convictions, regardless of whether or not they are spent or unspent. And we've also established that a certain period of time will need to pass before a person can apply for British citizenship after a conviction. And we've clarified the meaning of a persistent offender, and we went through a list of non-custodial sentences and other out-of-court disposals. Guys, and for those of you who would like to know more about UK immigration law, maybe you are an immigration law student, or you are just beginning your career as an immigration law practitioner, or you are a legal profession but you are not specializing in immigration law and you would like to know more, you are very welcome to attend a free masterclass where I provide an overview of 30, that is, UK immigration rules and errors of UK immigration law. I teach this masterclass on a regular basis, and if you register your interest at ukvisasuccess.com/immigration-course-free-masterclass, I will let you know when the next masterclass becomes available. And I've provided all the links in the description. If you found this video useful, you can do 3 things right now. You can subscribe to my YouTube channel. You can visit my free website at ukvisasuccess.com. And most importantly, you can share this video with those who may benefit from it. By sharing these videos, you may help others avoid refusals of their immigration applications. Because in immigration law, knowledge and clarity are the key ingredients to success. Thank you so much for your support and for your positive feedback, which incredibly inspires me and gives me fuel to create more and more videos clarifying various aspects of UK immigration law. Have a great day, everyone.